Morning, everybody. Welcome to our first People Hub of 2026. It's nice to see some familiar well, maybe not faces, but certainly names entering into this session today. If you've not met me before, my name is Victoria Brown. I chair the People Hub. It's a series of events that we do every year, normally bi-monthly, and they will be various things related to people. So if you are a HR professional, that I can see quite a few of you are, business owner, or you have some responsibility for people, then this hopefully you'll find as really useful sessions. So I am joined today, delighted to be joined by Claire McGuinness, who some of you will know and I've seen on some of these sessions before, who is a senior HR consultant at HPC and also head of operations. I also have Pam McColl, who is an employment law solicitor and director of ConwayMcColl Solicitors. So thank you, ladies, for joining me today.
Morning,
Morning, everyone.
Morning, everyone.
So we are going to be talking, as you know, about the Employment Rights Act today. But before we start, I just wanted to remind you, if you've not been in these sessions before, we are going to run through a series of a presentation today, a bit of sort of Q&A. I'm going to ask some questions to both Pam and Claire, and they're going to kind of, oh, sorry, if anyone heard that then, that was just something crashing down on my desk. I talk too much with my hands, I apologise. So before we move on, there is the opportunity to ask questions. Now, this is a really busy session, as you can imagine. We've got a lot to get through today. So what I would ask is if you drop any questions into the chat, or also if you're not using your phone to watch this session, please do just scan the QR code now. If you scan the QR code, you can then just pop any question on there. It can be anonymous if you want it to be. You can just ask the question. And then if we've got enough time at the end, I'm going to run through them. If we haven't, don't worry. We are still going to answer your questions. So we'll still respond to you after this session. We're also going to share with you after this session the slides, the handouts that we've gone through. So don't worry too much about trying to screen grab anything on the screen. So in December, the Employment Rights Bill received royal assent, and I think everybody, if it's fair to say, took a deep breath, because whilst we've been talking about it for some time now, it is now a reality. So we now have the Employment Rights Act of 2025. So we're going to talk through this in a session today. We are going to add a more series of Employment Rights Act sessions to the People Hub timeline this year, because we are conscious that there's a lot to get through. So don't worry, we're going to sort of chop this up into bite-sized sessions as well. But this one, we're going to go through what we know and what's coming up. So Pam, if it's okay, I'm going to turn to you first, please. Obviously, we are aware now we've got the Employment Rights Act. Could you tell us a little bit more around what we know now for the timeline and what we need to prepare?
Yeah, sure. So what's really interesting in all the information I've been reading about this is that there are still a lot of areas that are being consulted on. In the guidance, we have dates where certain things will come into force, and we have dates when it's expected certain things will come into force. So those dates have still got to be confirmed. We'll probably refer to those as we go along this morning. But at the beginning of January, provisions were introduced, which doesn't bring in any new laws at this point, but does allow for new laws to come in following the legal process during the next 2 years. So those provisions relate to 0 hours contracts, flexible working, etc. And they will impact what comes later on. So a brief overview: in force from next week, from the 18th of February, is going to be a number of trade union related amendments. So again, trade union rights, collective rights, a whole topic on their own. But essentially, that will touch on public sector check-off. Check-off is when union subs are automatically deducted from wages, facility time, balloting, rules around trade unions. So again, a lot happening in that area later on this year. Perhaps more commonly, there are changes that will precede changes in April to do with parental leave and paternity leave, which I'll come on to in a minute. 6th of April is a key date because we know certain things are going to commence on the 6th of April, and generally other things are expected to happen in April, which have not yet been confirmed. Again, we'll come back to these. October 26th is another key date. Dismissal and re-engagement or fire and rehire changes expected at that time. Extending employment tribunal time limits, that's going to be a really significant one. Duty to take reasonable steps to avoid sexual harassment, and the sort of two major changes in connection with sexual harassment planned over the next year or so. In December, there's a sort of slightly nuanced area of a seafarers charter. Not sure how many seafarers we have or who advise on that area, a little bit niche. And then again in 2027, there's further changes and amendments. Most significantly, of course, the change to unfair dismissal, introducing a much shorter qualifying period to claim unfair dismissal, which again we'll touch on. And along with that, the removal of the cap on compensation and the right to a written statement for reasons of being dismissed. So that's really a whistle-stop tour of the timeline. Most significantly, I think, on a day-to-day basis, from the 6th of April, the reduction in qualifying period for parental leave, currently 1 year, service is required, that will go to a day one right, and paternity leave, which is currently a 26-week qualifying period, will go to a day one right. But the key point is notices to take those types of leave will be able to be given from next week, because there is a lead-in period where certain criteria have to be met. So yeah, that's a whistle-stop tour of that timeline.
Well done, Pam. You did that in amazingly well, very succinct. But yeah, quite overwhelming as well, I think, when we look at how many changes we've got in play.
Yeah,
And
there's a lot.
and strange, as you say, Pam, that we're still we're unclear really on actually some of these dates.
Yeah, very much so, including sort of certain headline type amendments or changes that have really yet to be confirmed, which, in view of what's happened with a lot of these rights or proposed rights since the new government came into force, always leaves me with a question mark as to whether some of these will actually come into
Mm,
force. Because I've
mm,
obviously got a lot of movement in government as well, and you don't quite know which characters are going to be taking over and driving these things forward, and if they'll have the same appetite.
really
Um,
good point. Yeah.
but I think certain things we can certainly focus on and be ready for.
Yeah, yeah, absolutely. And there's certain things that we know, regardless of political persuasion,
Mm,
they're going to happen, aren't they? So
yeah, absolutely.
thanks, Pam. Right, I'm going to turn across to you now, Claire. Now, obviously, we've got the Employment Rights Act timeline that we've just run through there, but as employers, we have our statutory changes that are, as always, coming into play on the 1st of April. Would you mind
Yeah,
just talking us through that, please, Claire?
yeah, sure. So as usual, I mean, I think most people are kind of used to these changes coming in on each year. It's just a case of making sure we update our policies and not stay on any old rates. But what we've got from the 1st of April is the national living wage and the apprentice and under 18. So there's an increase in 50 pence on the national living wage. So 21 and over will become £12.71, currently 12.21. 18 to 20-year-olds will be an increase of 85 pence, become 10.85. Under 18s, £8, an increase of 45 pence, and apprentices, the same increase of 45 pence, taking apprentice up to £8, and then apprentices in their second year go to the normal national minimum wage. So remembering to kind of make those changes as well. But I think most common mistakes employers tend to make is just not reviewing the pay structures. So, risking accidental underpayments, and, there's also things like if you've got, I don't know, junior supervisor level pay, so that living wage creeps up to that pay as well. So it's considering other roles rate of pay as well. So is that you've got people who are doing a team leader or supervisor role, and they're just, a couple of pence above that living wage. So it's reviewing what that looks like as well internally. So yeah, definitely worth checking the pay bands. Someone slightly in a higher role shouldn't only be £1 or £2, ahead of that as when you get new starters. And then look at making sure you get your apprenticeships paid right. Over 19 in the second year, they go on to the national minimum wage. So just making sure we don't create any awkward pay gaps and things like that. We usually update the policy. Well, we do update handbooks and policies for all of our clients so that they're all ready to go out in advance of these changes. So yeah, ideally, people making sure that those new policies are distributed internally. Your managers know what those changes are. Payroll systems are updated, to make sure everyone's covered, ready for that. And then we've got the statutory payment rate. So this one is from April, from the 6th of April. And we've got the statutory sick pay increase, currently £118.75, and that will go to £123.25 with an increase of £4.50. Got some changes on the day one rate as well, haven't we, but in terms of the SSP. I'm not sure whether that's on the next slide or if we're on this one. But I think on this one, I think most people are aware of that because it's the one that's going to impact them, isn't it? Mostly coming up to these changes in the early ones. So what that means is that employees will now have a day one right to claim SSP from day one. So those waiting days have been removed, where you could currently, you can claim from day 4 SSP, but that will be from day 1. So if an employee is off for 2 days, then they get a pro rata of that SSP. You still need to be eligible in terms of what that £123 earnings eligibility, that bracket is still there, and you still need to follow internal policies and things like that to, phoning in sick and letting your employer know that you're in sick. But ultimately, if you're off for a day, you would get SSP from that day 1. So I think that'll have a little bit of an impact on a majority of employees, particularly SMEs, might notice it a little bit more if you have high absence levels. So there's numerous things to get in place for that now, particularly any absent managed policies and triggers, and training your managers, making sure that they know what that process looks like again, so we don't fall down on any underpayments. And then the statutory payment rates from 6th of April, all of these family-friendly payment rates we've got, all with an increase of £7.14 across the board. So no significant impact in the increase, but I guess, again, for small businesses, if you've got, a small business with 2 people on maternity leave and or one on paternity leave, one maternity leave, it's kind of, it can have a bit more of an impact. But again, for all of these family-friendly increases, then updating policies, making sure your managers know what the pay rates are, making sure your payroll's up to date, and some training for on these day one rights as well that are going to change that sit alongside these pay rate changes.
Thanks. Thanks, Claire. I think that's all on the statutory now as well, isn't it? Okay, so if we move on to the parental leave now. So just turning still to you, Claire, could you just let me know in terms of when the day one rights are going to sort of kick in for this for paternity leave and unpaid parental leave? When's it expected to come into effect?
Yeah, so this is expected to come into effect on 6th of April. So everything's happening on this bank holiday by the looks of things. But every time everyone comes back on the Tuesday.
I'm going away.
So yeah, from April the 6th, paternity leave and unpaid parental leave become a day one right. Effective, what that means is that somebody can take time off for the new child as soon as they start a job, rather than having to wait months when they first join. So right now, employers often assume that, well, at the moment you would need 26 week service for paternity or 1 year service for unpaid parental leave, but before they can take that time off. But that's going away. That's going to change. Going to become from day one. You would still need to give the relevant notice. That doesn't change, and it doesn't change anything in terms of pay. You're not entitled to pay from day one, but you are entitled to take the leave from day one. The practical effect of it is that someone can join and immediately request paternity or unpaid parental leave. So making sure onboarding policies are ready for that. And as I think Pam had touched on it earlier, there is that transitional window from the middle of this month. So from next week, when people can start to give you notice of that time, so that they can take it from April.
That's a really important point to make, I think.
Yeah.
And Pam, what do you think from an employer perspective? Like, what should we be doing to prepare for this change?
Yeah, I think some of these family-friendly policies are interesting as well because statistically there's been a fairly low uptake of parental and paternity leave. Thank goodness, because it's complicated. And shared parental leave, that's again a lot. So, and the main reason, of course, is because it's unpaid. So remember, companies can rely, or employers can have the default scheme, or they can enhance it. And sometimes that's an incentive for people to take the leave and retain staff. So it's sometimes worth thinking outside the box if you're working in an area where it's hard to find or retain staff. But in terms of preparation, the obvious ones are to revisit policies, or if you haven't got policies in place, make sure you take good advice and get them in place, because policies, first of all, should at the very least reflect the legal position. They shouldn't be contractual, because that will bind an employer and make it more difficult to make changes, and that it's not necessary for policies to be contractual. So revisit those, make sure they're up to date. If the statutory scheme isn't paid, but if an employer does pay enhanced paternity or parental, that should be reflected in their statement, their main statement of terms and conditions, which tends to form the basis of a contract of employment. If you use electronic HR systems, make sure they're updated to account for these type of absences. It seems a really obvious one, but maybe one that's easy to miss. Train staff, train your managers, train your HR people, and attending webinars like this is exactly what should be happening. Get managers on things like this because it's about awareness as well. You know, people have got their day job to do. It's, you know, people like me sort of deal with this stuff all the time. But if you've got a different role in a business, you might not be aware of these things. Consider workforce planning. Is your demographic such that maybe you might lose staff for a period of time through taking this type of leave? As we've already said, keep an eye on further changes as to whether these things will be confirmed or will be changed again. Interestingly, when reading the sort of government guidance that's come out of this, it's all very much about making employees aware of these rights. But actually, there isn't a duty on employers to tell staff about these things. And I sort of checked that again because of the way some of this guidance was written. So there's not a specific duty where you must announce all of this. But certainly, if you've got resources like policies or online systems, make sure they're up to date and accessible, because I think the more people know, the less likely mistakes are going to be made.
Absolutely. And there's nothing more embarrassing, is there, than an employee notifying you of a change that you're not aware of, and then you having to go and understand that and make that correction, because it can have that damage to that psychological contract as well, can't it?
Absolutely. And I suppose some people might think, you know, we don't want to promote this type of leave because we don't want people going off on this type of leave. But as I say, statistically, there's a low uptake. I don't know if that's going to change anytime soon if it's not paid. But yeah, I think the more people know, the better.
Absolutely. And I don't know about you both, but personally, my experience of most of the employers and clients that I work with, they do already do this. You know, a lot of them will, if somebody starts and they're just about to have a child, they will let them take that leave. So I'm not sure this one, I agree, is going to have as much of an impact, but I think if we just move to the next slide, Maisie, and Claire, obviously you touched on this before from the SSP perspective, and Pam, if we can just sort of consider this now, if you could just again, if, sort of, I know Claire has done this, but if you can just again outline the change, because I think it's so significant, it's really important that everybody on the call is fully aware and prepared for this change.
Yeah, absolutely. So again, this is one of the changes that's expected in April as opposed to absolutely enforced. But this is quite a significant one actually, because this removes the current 3-day waiting period that applies to sick pay. And we know there can be linked periods of sick pay, but that's again another conversation. So currently people have to wait 3 days, so essentially don't get paid for the first 3 days of sickness, and it would only kick in on the 4th day. So from now on, employers will have to pay from day one. And again, quite a few years ago, employers used to be able to claim that back. Of course, that doesn't happen now. One of the criteria for getting SSP was that the employee had to be paid at least the lower earnings limit to qualify for SSP. That is changing also. So currently the lower earnings limit is £123 per week. What the government are proposing is that so SSP, as Claire said, is currently £118.75. But actually, there's going to be a different calculation for people who are earning below the lower earnings limit, and they will get 80% of their salary, and to make sure that they don't go above the statutory sick pay rate. So I think people have to be aware that there's going to be a different calculation for people earning below that limit. Interestingly, the government thinks that having day one rights will actually help people come back to work in terms of phased returns to work. So they think that if, for example, somebody normally works 5 days a week and they return to work for 3 days a week, they're still going to get SSP for the remaining 2 days that they're not working. So an interesting thought process, interesting reasoning for this. But yes, the key point is no waiting days and a different calculation for those currently earning below the lower earnings limit.
Thanks, Pam. I know I've talked to a lot of finance directors and, looking at their sort of forecast and their budget from sort of April onwards, and it is quite concerning to many, particularly if they've got high sort of short-term absences within their, and you look at the likes of hospitality, for example, call centres. We know that there can be high short-term absences. So, Claire, what guidance would you give to people today? We know, well, we think it's going to happen. I wouldn't mind putting a bet on it that it will. But that's going to have some significant impact, particularly for some of the people on this call today, that no matter what the size, it has an impact. But obviously, the larger that you are as a business, and if you've got absence issues now, this could be quite significant to you. So what would your recommendations be? What could we practically do now?
Yeah, I mean, as you know, Vic, we kind of try and educate our clients, don't we, along the way in terms of managing their absences now anyway. And when we've been going out to see clients, it's trying to just really relay the importance of getting the policies in place and getting an actual absence management framework in place. And I think what that does create is just the consistency. So one, everybody's being treated, fairly, not necessarily the same because individual circumstances are what they are, but that process is consistent and fair. One, that we can manage the absences in terms of levels and what do we do with that when we've got that information, and what are the consequences of that, and have we got these processes in place so as that employees won't take advantage of that day one right. Ordinarily you would take 3 days off and not get paid, and that was the incentive to not do that because you would be losing a day or two's pay. Whereas now, yes, it would only be a percentage of what that threshold is, or the lower earnings, but it still could essentially be £50 as opposed to nothing for 1 or 2 days off. So if you've got a business with 4 or 5 people off at any one time for those waiting days, then it's going to, in the long run, it's going to have an impact. So I think the importance of managing that and making sure that we do put processes in place for those sporadic absences is just going to be key. And that employees and your workforce get to know what that looks like. We become consistent with it, and just able to manage it better. I think we can hope, with the view to, if we've got a process in place, we can try and manage it so that people don't do it. So if you are getting those, Monday and Friday patterns because, people just do, and now they get a couple of pounds as well. So there has to be consequences to manage those short-term absences, and as well as, familiarising yourself with being fair in what those reasons for the absences are. So there's a day one right to sick pay, but that we're not being overly, strict when we are dishing out consequences because people are off for underlying medical conditions, and we have to take that into consideration as well. If we're managing absence via the Bradford factor, making sure that we make any adjustments where we need to. So all of those things still stay the same. But for employers who don't necessarily have any triggers in place or an absence management framework in place, I think that's potentially going to be the fall down, whereas you might lose control on it a little bit and eventually it's going to have an impact on the budget, isn't it? So preparing for that.
Absolutely, yeah. And quite significant. I've looked at some clients who've got, hundreds of staff, and they're looking at the absence and the short-term absence where people are still taking, 1 or 2 days, as you say, Claire, Mondayitis. And it's quite a significant impact just on SSP. And that's before you even think around productivity and, all the consequences that we're aware of short-term absence. And as you say, I think that the absence framework, that's the key, isn't it, really? It's not just putting a policy in place. Because I've seen so many fantastic absence policies, but then when I sit down and obviously with my sort of software hat on and I ask, right, well, where do you record these absences? What do you do with them? And a lot of the time, there is no recording of those absences. They're not using a piece of software, or if they are using a piece of software, managers aren't trained and equipped to understand the importance of logging those absences. So you've got to look at it holistically, haven't you? It's not just let's
Yeah.
update our policy and expect everybody to understand the significant impact this could have on your business.
Yeah, I think there's a lot of employers have kind of got the head around it, going, oh yeah, that's the day one, right, and it won't impact us that much. But I think when people start to get comfortable with it, in terms of, oh, I was off sick and I got paid, I think it's just only going to escalate. So I think before April comes in, get those policies in place, get the framework in place. What does that look like? It doesn't have to be anything overly complicated. It can be the framework within your policy. Train your managers on what that looks like, and be consistent with it.
Absolutely. We could probably talk about this one all day, but let's move on because I'm conscious we've got a lot to
go. I can't. Pet hate, as you know.
Oh, okay. We know that we've got changes coming around sort of sexual harassment disclosures and how they're going to be treated under the whistleblowing law. Can you explain a little bit more here to everyone and what implication that's going to have for them?
Yeah, absolutely. I mean, it's very not surprising, and it's very obvious in all the reading that the government are really going to try and come down hard on any form of sexual harassment and to drive that out of the workplace. And in this respect, just to sort of recap, for blowing the whistle or making a protected disclosure, there's two types or two levels of protection. One is the right not to be unfairly dismissed or dismissed because you've made a protected disclosure or blown the whistle, and also a protection from suffering a detriment again if you have blown the whistle. And you may also be aware that in settlement agreements, for example, this is such a key area of law that you can't sign away your rights to blow the whistle, in a sense, even if you can settle many other things. So to blow the whistle and have legal protection, there are certain criteria. Firstly, the employee must have made a disclosure, so that's not just a grumble, that's actually raising a concern. The subject matter, which is what's important here, must fall into one of 6 categories, and now there's a 7th. So, for example, that the whistleblower may think the employer is behaving criminally or fraudulently, and there is very specific categories. And now there will be a category that says that the employee believes that they have been sexually harassed or they feel they may be. And that's sexual harassment as defined in the Equality Act. So they must have a reasonable belief that this has happened or that it may well happen. And key to this is it mustn't be personal. They must believe that it's in the public interest to make this disclosure. So this is one of a couple of amendments to the law to be aware of if people do raise this concern. Do you want me to just go on a little bit about perhaps how employers should be aware of this, Vic? Are we good for time?
Maybe what we'll do is we'll follow that up if that's okay, Pam. Just conscious
Yeah.
got a little bit more, and we could probably do maybe a bite-sized session on that. And Pam, if you want to lead that, that'd be great. You're too good, you see, you're too good. Can we just move on to the Fair Work Agency? So I don't think people are talking about this enough. And when we look at, from a health and safety perspective, where we have HSE just turning up to on site unexpectedly, that this to me feels a little bit like that, and people need to make sure that they've got their ducks in a row. So Claire, if people on this call don't know what the Fair Work Agency is, can you just explain a little bit around what this is and what considerations we need to think about?
Yeah, sure. So this is a new one, and this again launches beginning of April, 6th of April, 6th, 7th of April. And what it is, it's a single joined up regulator for workplace rights, really. So what it enables is employees to be able to contact the Fair Work Agency direct. I mean, if you've got, any kinds of statutory issues, so if you're saying I haven't been paid holidays or been underpaid, or, if for those, like we were talking about earlier, those small accidental errors on payroll where you haven't done minimum wage increases and things like that. It's that go-to place, a little bit like HMRC, but a body for employers and employees to go to. So if your compliance is a little bit patchy, or any of those pays are wrong, or even for a disgruntled employee, they would initiate, or what I imagine, so what the plan is that they would then initiate an investigation into what that alleged underpayment or statutory breach is. So I'm not saying there's a risk there that people are going to get investigated left, right, and centre, because I genuinely don't know what that looks like yet, whether that would be a phone call like you would get, or whether you get a visit from HMRC. I don't know, and I don't want to, scaremonger people into going to get inspected every time somebody makes a claim, but that could be the case. So it's a case of, if employees can contact that agency directly, the sensible move now is to audit, do an audit and get all of these correct new legislation payments in place, and fix any gaps, document everything properly, and again make sure your managers are up to date with what this looks like, and what potentially could be the fallout be of it. So it's not a new law, it's a sharper enforcement, if you like. So for those holiday pay errors that we get so many queries about, where people have been paid incorrectly on holidays, or even sick and things like that. So ideally what you want is to have those processes and that go-to place internally. So if that people have got these minor grievances, they've got somewhere to go before they go externally to this Fair Work Agency. So your own safety net before anybody needs to go outside and launch some kind of an investigation for what we may consider to be a trivial breach. It doesn't necessarily mean that to an employee who hasn't been paid correctly. So that's what that will be. I don't really know too much about what else it would look like, to be honest, Vic, because nobody's used it yet. But yeah, I'm sure we'll have more information on that. Well, I would imagine so, soon enough.
Yeah, no, we don't do it. It's the unknown, which is quite scary in some regards. But I think that point being, just make sure that you've got everything documented, that you feel comfortable that if you were sort of did have an inspection, you've got everything in place, and not all over the place in the one place. And obviously, we do say again, if you haven't got sort of software, then that's a great opportunity to pull all that into one place rather than in a cupboard. Okay, thank you. Maisie, would you just jump to slide 15? Because I just am conscious of time and I knew that we obviously got a lot to go through, which is one of the reasons why I wanted to do sort of headline today and then probably cut this up a little bit more and do some bite-sized sessions for you over the next coming months. So if we know obviously we've got a lot to consider, but I thought if we can just concentrate on what sort of it should be on the radar now for employers. So Pam, would you be able to kick us off in this area, please?
So fire and rehire, this is one of these areas that's had a lot of headlines over the last few years. But interestingly, again in the guidance that I've been reading, there's apparently less than 1% of employers might use this fire and rehire strategy. And basically, as we all, I'm sure, will know, that in order to change somebody's terms and conditions of employment, that is absolutely possible and often necessary. But there's a consultation process to go through. There has to be sound business reasons, and the aim is really to achieve agreement with the employee. If agreement can't be achieved, then an employer has the option of giving notice, much like if you were terminating someone's employment, and after which new terms and conditions would take place. So what's happened in a lot of high-profile cases is that the employees have been dismissed, but then either new people or the same people have been immediately rehired into these positions, but on lower pay, reduced terms and conditions. And this is really what the government is aiming to, or said they were aiming to ban. It's not going to be banned. Again, this is one of these changes that is expected in October 2026. There's still consultation ongoing. So the proposed change is to add that type of dismissal to potentially for it to be a fair reason for dismissal, there would have to be certain criteria that would have to be established in order for an employer to use that as a fair reason to dismiss people. Otherwise, it would be an automatically unfair dismissal. So the employer may have to produce financial evidence that the business is struggling and that certain changes had to be made. So it's, I think, one that should be on people's radar, especially with large companies.
Absolutely. Thanks, Pam. Can we move to the next slide, please, Maisie? Claire, would you want to talk us through harassment and sexual harassment prevention, please?
Yeah, sure. So these changes, more changes on the harassment and sexual harassment prevention expected October this year, October 26th. And what we've got here is we've recently had, I think it was the end of 2024, wasn't it, where we had the prevention of sexual harassment, and now what we've got coming into play is harassment and prevention of sexual harassment and third-party harassment. So what employers are now going to need to do is, whereas we currently have to take reasonable steps to prevent it or to show that we've prevented sexual harassment should anyone bring a claim, we will then have to take all reasonable steps. So in terms of what else could we do, what's the difference between all reasonable steps and reasonable steps? And I think that's going to depend on individual employers and individual workforce. What additional steps could you have taken to prevent that third party sexual harassment? So it's not necessarily this will cover all different types of industries. You know, it's not just those high risk industries some people might consider to be entertainment or hospitality or retail, but it's offices as well. You know, you've got suppliers and contractors coming into offices, so it's across all industries. What those additional, as in all reasonable steps, will look like will depend on what type of industry you are. To give an example, as we're talking in hospitality, then it would be for example, taking proportionate steps to prevent harassment from third parties, might be warning a customer or a visitor about unacceptable behaviour, refusing service temporarily if there was an allegation of sexual harassment, or essentially maybe even banning them from the premises. Whereas now taking reasonable steps would be, you've dealt with it, done an internal investigation. Additional all steps could be to ban somebody from the premises, and that would be considered proportionate in terms of what your industry is. So yeah, ideally now start to get that training in place, and that's going to be for everyone, senior leaders, managers, employees, making sure that we've got that training, we've got those. What does the process look like? How do you raise that if you feel you have been sexually harassed by a third party? What does that process look like? So we can really demonstrate that we've took all reasonable steps to prevent it. That's what we're going to need in any tribunal, to be able to demonstrate that we've got that.
Thanks,
And
Claire.
we obviously want to prevent it.
Yeah, of course, absolutely. Pam, this is obviously a big one. This is probably no doubt going to keep you very busy when this does come into play. So would you like to just explain a little bit more to everybody?
Yeah, absolutely. And again, this is a really significant change, because the purpose of the employment tribunals was always supposed to be swift justice. And to be fair, up until COVID, on the whole, compared to other areas of law and other court systems, I think we were achieving that. But as we know, there's huge backlogs, which in employment law is very difficult because witnesses move on, people lose interest, and there's a claimant and a respondent who are still having to deal with these issues. So yes, expected from October. Currently, you have to submit a claim within 3 months of termination if it's an unfair dismissal, or from the discriminatory act, or the last in a series of the discriminatory acts. Now that will be extended to 6 months. That is, of course, subject to stop the clock ACAS early conciliation. And of course, the concern here is that if you add the stop the clock in to potentially 6 months, we could potentially be way down the line, much further on from the termination or the discriminatory act than we currently are. And I think that is a concern. I think it will be good for maternity issues, because women who've had babies and partners who've been part of that will know that it's a busy time, and thinking of submitting a claim if you think you've been discriminated against is probably quite low down the list of priorities in those first few months. But essentially, it's going to be a really important one, because you may think an issue or an employee has left and you can sort of breathe easy after a relatively short period of time. But then maybe 6, 7, 8 months down the line, a claim may drop. So definitely one to keep an eye on. I've not read anything to suggest that that is questionable. It seems that will happen. So, and it's tied in with the day one rights, the shorter qualifying period, and the removal of the cap on compensation as well, just to make claims easier to make for unfair dismissal.
Absolutely. Thanks, Pam. And just on that note then, Claire, obviously, when we talk about the unfair dismissal changes, this is an interesting one. It's expected in January. And if it does come into force in January, people really need to be thinking about that now, don't they? And they're not. They're sort of going, yeah, that's January, when actually some of the people that are taking on now will have that impact. So can you just talk us through those proposed changes and what we need to be doing now to prepare for that?
Sure. I mean, initially this was going to become a day one right, which we thought, wasn't it? So we've got a little bit of a buffer. So the 2-year period now that you would need to have the right to claim unfair dismissal has now gone to 6 months essentially. So we've got that 6 months in place. I suppose a probation period the government have set for that. That doesn't change the fact that if you have a 6 month probation period, or you have a 3 month probation period internally, or a 9 month, or you extend the probation, that's still your internal probation process. This is its own 6 months. That regardless of whether you extend somebody in probation or not, they would have the right to claim unfair dismissal after 6 months employment. The day one rights still stand in terms of discrimination and whistleblowing. You don't need any length of service for that. But yeah, you're right, Vic, in terms of people are kind of pushing this to the back of the head, going, it's January 2027, it's only February now. But in the reality of it is that if you were employing somebody around about July or August this year, and that 6 month probation would be up in January 27, then that day that right would kick in. So they would have the right to claim unfair dismissal from the end of the probation. So really need to think about our recruitment, and what does it look like within your probation period. What we can't do is just dismiss somebody after 6 months, and say we just they weren't meeting the standards, we didn't like them, or they didn't fit. We're going to have to be able to demonstrate. I think Pam touched on the very beginning, they've got a right to, that written statement as the reasons why they've been dismissed. And what does that look like for us? What do we need to do to be able to demonstrate that they're not dismissed unfairly? We need to be able to demonstrate that it's related to an underperformance or conduct reasons, and the reasons why they're not suitable for that business. So your one-to-ones, your 3 month reviews, 6 month probation reviews, the whole of that performance framework is more important than ever. My advice would be to get that in place, start it now, so that when you do start recruiting in the summer, you've got those processes in place, and your workforce is used to having them. They know what they look like, and you got those reasons documented for why that person is unsuitable, and why they've been dismissed fairly. Essentially, that's what we're having to prove. What comes with that is that there will be no cap on the compensation either. So at the moment, where we would say for an unfair dismissal might be similar to a redundancy payment of a week's pay for every year you've worked, there'll be no cap on that. So extremely costly, even for a short-term hire. You could recruit somebody for 6 months, dismiss them the day after that 6 months, and they've got right to bring a claim. AI doesn't help, makes it so much easier for people.
I was just about to say that, Claire. It likes to tell people to do it as well, doesn't it?
Yeah.
Unfortunately.
Yeah, it's driving me insane at the minute. So yeah, it's making it so much easy for people not to need a lawyer and not to pay out for anything. Even anyone can go and put it in, and it'll give you a full EC1. So yeah, really important that we get those reasons documented within that first 6 months, that we can demonstrate we're being fair.
And you have a good lawyer to defend it. Absolutely. And then I'm just conscious of time, but this is obviously the last one. Pam, could you just talk us through the 0-hour contracts? I know it's expected 2027 too.
Yeah, so again, when you start to look at this area, there's lots of written on it, and again, a lot not finalised at this stage. There's been various suggestions, and the way they categorise this is changes to 0 hours, low hours, and agency worker contracts. So they're kind of grouping these types of working patterns together. Changes are being discussed with a view to them taking effect in 2027. It literally doesn't give a month or anything, but there is still a lot of consultation going on. There are talks of maybe having certain guaranteed hours. I question, how is that different from any other kind of contract anyway, a fixed term contract or a part-time contract? I don't know. They're really trying to work their way through this. And there's also talk of a reference period. And discussions have ranged from this should be a reference period of 8 hours per week to 25 hours a week. And I think the aim here is to try and use that period of time to establish a pattern which may form a minimum entitlement for this type of pattern of work. I mean, again, 0 hours contract, it gets a bad name. I would imagine a lot of us know where the 0 hours contracts, which is essentially a casual contract, works very well. People can choose whether to accept the work or not, and the employers can choose whether to offer the work or not. And I think that's what's making this all very difficult. So we know that exclusivity clauses went some time ago. So that used to be the case where employers would, or people who engaged people to work for them would say, yeah, I'm not guaranteeing you any hours, but you're not working anywhere else either. That can't happen. So in a sense, it's one to watch because there's what we have written at the minute is more about the discussions around it, and nothing's really firmed up just yet.
Yeah, I get so many questions on this right now, and I really do hope that the government consult and consider this, because, like we talked about, I can see a lot of hospitality clients are on this session now. It can be beneficial, and it potentially would have a huge impact if not thought through and implemented correctly. So, as you say, Pam, want to watch, really.
Yes, definitely.
Well, thank you so much, ladies. I really appreciate your time and your expertise today. We haven't got time for any questions. I know there have been a few. So what I will promise is that we will send them across to Claire and Pam to look at and to consider, and we will get back to you, and we'll respond and share with everybody, because I'm sure people are all asking the same questions. I've got on the screen now Claire and Pam's details. We will share these also. I know there are a lot of you that will know Pam and Claire, HPC, and ConwayMcColl work in partnership, so no doubt you will have met both of these fantastic ladies along the way. Also, we do have Lee, who is on the call, who's one of the sponsor of 1HR. So again, we'll share those details if there is anybody that wants to explore software. Without plugging that too much, I think we've demonstrated there's an importance. So if you haven't got something, maybe look at something. If not 1HR, certainly look at investing in a HR system for these changes. We are going to be back in March. We will publish as well a series of events. So what we are going to start to do now is break down some of the points in the timeline that we've talked about today, and go into more detail and deeper dive on each of these areas. So you're more than welcome, obviously, to attend any of them. If you think that you'd like anyone else to attend and find this useful, we are a community, and we are looking to support one another. Dependent, I know there's a lot of people in this room that are HR experts, employment lawyers, and there are some people that are quite new to business as well. So let's all go on this journey together and ensure that we're compliant. Thank you so much for attending today. Have a great rest of your week, rest of February, and I will see you in March.